Good morning, everyone. We are really pleased to have this webinar, our third webinar in a row today. Some of you might wonder that it's in English, two German guys speaking English, but we have a lot of people shown up and asked us to provide this webinar in English, so therefore we decided to do so. I'm really happy and honestly a little proud that we have Tim here with us. Tim and I know each other well. Tim knows Business Keepers well, and we are working on really complicated data protection questions together. So yeah, it's my pleasure to introduce Tim Wybitul.
Hey there, good to have you on this webinar. As Kai already said, I'm Tim. I'm a partner with Latham Watkins in the Frankfurt office. I have the pleasure to head the privacy team in Germany. I also have the doubtful pleasure to be the appointed data protection officer for the German offices of Latham. So I have the opportunity to look at these items from both directions, not only from an advisory perspective, but also from an in-house perspective. And I guess we can promise to touch base on a couple of highly interesting topics. What would we like to talk about? Before we give you an overview of what we brought to the table, we would like to encourage you to ask questions, to use the chat function. Otherwise, it would make a lot less fun for us and would give you a lot less opportunity to make the best use of this webinar. So please don't be afraid of asking stupid questions. I do so regularly and the answers often bring me most. So no worries about any questions. And we are fully aware that in a webinar like this, the existing knowledge of data protection issues will vary widely. Having said that, we will take the German situation as a blueprint. Where we talk about national member state procedural laws and particularities, we will use Germany. If you have questions about other EU state jurisdictions, we are happy to try our best. We will not be able to answer questions around the US, CCPA, or other issues, but that's not necessarily the topic we're discussing today. So we will touch base on a couple of major points today. As we mentioned, it's one hot topic these days is GDPR damage claims. In a second, we will explain to you why this has become such a big issue in courts and out of courts too. We will give you an overview on DSARS, as one would say in an English surrounding, which is the abbreviation for Data Subject Access Requests. This is something where the GDPR has brought some changes that are somewhat problematic to quite a couple of firms because they require a structure to comply with the strict requirements of the law. Talking about compliance, we will give you an overview on what's happening with regard to fines across the EU and across the German market. We have seen some very interesting developments here. Plus, we have seen announcements of very, very high fines. We have seen even one binding fine of 50 million in France, and we're going to share some light on the details behind that. Last not least, we're going to talk about the recent ruling of the European Court of Justice, the CJEU. I'll use the abbreviation CJEU for European Court of Justice, otherwise the webinar would take 1.5 hours. Beg your pardon for that. And we will show you what the challenges are, how to deal with that judgment, and what solutions are available. Moving on from there, we're going to give you an overview on data privacy and internal investigations. And we're also going to point out to you why this topic is going to receive a lot of extra attention, probably very soon. And last not least, we're going to give you an overview on where employee data protection law is going in Germany these days.
And I mean, these days, of course, we all see that more and more data is stored in clouds. So, of course, the whole discussion and clouds typically up to now are US-based or belong to US-based firms. So, therefore, of course, this is a topic we are questioned quite often by our customers. Is it a problem to store data in the cloud? I mean, let's face it. If we're talking about a whistleblowing solution, there might be sensitive data. And if it's sensitive data, we ourselves would question if a US cloud account would be the right account to store these data.
And we're going to touch base on that when we talk about the CJEU judgment.
Good.
Okay, starting with claims for damages in GDPR. You will have noticed that virtually when the GDPR came into effect and in the transition period 2 years ahead of that virtually everyone was talking about the huge fines and what's going to go on there and how it's going to change the market. 2.5 years from the GDPR, or almost 2.5 years from the GDPR coming into effect, we can say that yes, enforcement practice has changed massively. But we definitely need to accept, I would even say, that this has not been the biggest game changer so far. The biggest game changer so far probably has been that you see a huge number of claims for damages, for GDPR damages. And we're going to give you a little more information on why this is so interesting. One thing you got to know is that, let's say, after a cybersecurity incident, when personal data gets disclosed, gets leaked, gets hacked, whatever, normally you don't have a material harm, like a financial harm. In German law, under normal circumstances, you don't get compensation for immaterial damages. And this is one of the big game changes brought along by the GDPR. The GDPR Article 82 is a provision that basically provides for compensation of immaterial damages. What this is, we're going to get to this a little later, but this is something you gotta have in mind when you look at the current situation in Germany, in the UK, in other EU member states. Let me move to the UK because that makes it easier for us. I don't have to talk about my clients in that scenario. You see a lot of cases where you see mass claims. There is, for instance, one law firm that's specialized. Actually, it has been specialized, in my perception, pretty much on car exhaust claims or other consumer claims. And these firms now have found something which is described as a new business model with GDPR damage claims. You will see a huge number of claims brought forward either by consumer firms, like consumer representing law firms like Hausfeld, or by privacy NGOs like None of Your Business, short NOIB. And there you see a real change. Actually, you also see a lot of phishing for clients by litigation funders. You also see in Germany, one case which pretty much is the benchmark. 4 hours after a huge data breach became publicly known, they had their first landing page online and were advertising for clients for claiming immaterial damages. So this is something where you see a lot of change. One other game changer is that these claims can be sold. You can just sell them, you can assign them to someone else. So in other words, it's very, very easy to bundle them. And that's something which makes it so much easier for plaintiffs to prevail in court, because you don't have the effort, the time needed to do 1,000 different cases. But very often when you have a data breach, the facts of the case are either identical or at least highly similar. So that makes it much easier to use legal tech, for instance, to have a huge number of claims with very little effort. So that's something where we see a lot of change. For instance, in Germany alone, our team represents clients against several thousand plaintiffs, and we are talking about much larger figures in the UK. So this is where this entire thing is going. Mass action, or basically by bundling claims, you have very similar effects to mass actions in EU jurisdictions where you don't have mass action mechanisms. And then you got to be aware that there's also a link to the supervisory authority proceedings, because any plaintiff going to a civil court, actually Politico just did a piece which pretty much said, you get a GDPR complaint, skip the regulator, go straight to court, which is a fair description of what's going on these days. However, what we see is that virtually in every case, there are a number of complaints to the data protection authorities, and that makes a lot of sense, because first thing, you want to generate some noise when you are fishing for clients as a consumer lawyer. Plus, it also makes a lot of sense from a strategical perspective, because it gives you the chance to request access a little while later, once the data protection authority has conducted its probe, its investigation. And one thing you got to know is that they are legally, statutorily obligated to do an obligation if they receive a receipt, if they get a complaint. So that's where we are these days. Courts have been dealing with these cases very differently, from I don't see any damage at all to the one court in Düsseldorf recently awarded 5,000 euros to one plaintiff just for the fact that an access request for information, according to the court, was responded to belatedly and not sufficiently transparent. 5,000 euros is a lot for, in my view, even if all the facts were established, a minor transgression. Just keep in mind what huge risks could amount with cases that touch on personality rights a little deeper. So that's what.
And I mean the new risk, as far as I understood, because of course we discussed the content before, is the level of thousands of these claims in one to restructure them in one case, right?
That's true. Okay. The big point is a data protection violation, or in very rare cases, if something goes wrong with regard to data privacy or with regard to IT, you very rarely have cases where you only process personal data of one individual. Normally, it's a huge number of customers or of employees. So that's where this change comes from. In a litigation scenario, you have a lot of leverage there. So how do these cases work in court? It's pretty interesting, because at the end of the day, this is classic tort law. And so let me give you, and I'll do this very quick because it gets technically, even though it's highly interesting, not only to lawyers, as I know. What do you need to establish a claim? You need an infringement. And here you've got the first thing, who has to prove the infringement? According to plaintiff lawyers, the mechanisms of the GDPR, in particular the accountability principle, established in Article 5, Paragraph 2, and Article 24 GDPR, is meant to establish a shift of burden of proof. When you have a duty of accountability, they say that results in a burden of proof with the controller, with the enterprise that's processing personal data. Whereas we in court argue, no, That's not a shift of burden of proof. That's not in line with most EU member state procedural laws, but this is rather an obligation towards the data protection authority. It's going to be interesting to see what courts will make of that. In Germany, so far, we have prevailed with that. And yeah, but we are going to see a lot more decisions in that field. And
so that's your guess?
I hope we prevail with that.
Okay.
Next thing here is if, let's say, either a violation has been proven, and one thing you got to keep in mind in any, for instance, cybersecurity scenario, even granting insufficient IT security is a violation of Article 32 GDPR. So not having sufficient IT security, data security in place is a violation of may be a violation of the GDPR in itself. And the problem with that is some people might argue that if there has been a data breach, there is some degree of indication that the data security was insufficient. Personally, I don't see it like that, and anyone who ever had to counter a large DDoS attack knows that at some point of time, IT systems are bound to fail, and you cannot exclude every risk. But nonetheless, this is what plaintiffs do and what their job is. And I'll be very candid, we represent enterprises averting those claims. So I'm not saying that my view is the neutral one. I'll be very open. I'm on the defendant side, and these are the views we present to courts. Next thing is, what exactly is, once you have established a violation, what's the damage? What's the damage to be compensated? Like to someone who has studied law in Germany, and basically you have a very reluctant tort damages law. And it's really different in other jurisdictions. Most European lawyers have the picture of a hot cup of coffee and high damages for that, or putting your poodle in the heater and being surprised that the poor pet dies of that, and you get huge compensation for emotional distress. And if you listen to what plaintiffs argue, it's not too far from that, and they got a fair point. The GDPR provides to compensate for immaterial damage, and now a court is in the position to say, so what is that? We basically argue that you need to establish palpable damage in order to be compensated. So at the end of the day, this comes to a materiality threshold. Plaintiffs feel that there is no wording in the GDPR to establish that view. Again, it's going to be very interesting what the European Court of Justice, the CJEU, is going to make of that in probably 4 or 5 years from now. That's how long such a procedure normally takes. But this is going to keep courts busy for a long time, given the circumstances we described, presented on the last slide. Next thing is you need causality. So it's not any violation, but the violation must directly lead to the damage established and claimed and the compensation. So it's basically, this action must have been a violation of the GDPR, and it must have directly led to the damage asserted in court.
But let me ask here, yesterday we spoke about this, and you explained to me causality is sometimes much more abstract than we all think.
That's true, because you often see in court cases where the plaintiffs argue that the information regarding the data being processed was incorrect, or that processing agreements were not concluded in full compliance with Article 28. My personal view is, or at least the view I present to courts, is that this is a far shot and you need a direct link. But there's obviously the other alternative. And again, we have seen this one case in Düsseldorf where the court said 5,000 euros compensation for a belated data access request. And the reason for that is that in the recitals of the GDPR, one of the descriptions for immaterial damages you see is lack of control about your personal data. And so the plaintiffs argue that in any case where you don't act transparently as a controller, as the enterprise processing personal data, that in itself establishes a lack of control, and that this would be causal, that this would basically directly cause damage. So we are having interesting court cases, quite a number of them. And one of the things you got to be aware of, you get a joint responsibility, you get joint liability. So let's say your firm uses a provider and that provider gets hacked. You can't just argue that, hey, this is none of my business, I'm out. But rather, you have the joint liability. Everyone involved, every entity involved is liable. And to get out of that, you must prove that you didn't have any due in the violation itself. And that is a very high burden of proof. So that's a massive threshold. And interestingly, the initial reflex of most companies in a controller, processor, sub-processor, sub-processor scenario, and that's just normal. I mean,
absolutely,
you don't process your personal data yourself. You use, I'm not going to mention names, but you use this large operating system, you use this large document system, you use so many providers, and these are all processors of your personal data. And obviously, they use a lot of sub-processes. And so this joint liability, that is a big thing, because it's very hard to get out of that. And in essence, you get a proof that you were entirely innocent of the violation happening, of the damage coming into effect. So, and that's one of the reasons why these cases are far from simple. Next thing is intent or negligent actions are necessary. And again, when you are in a modern world scenario and you use processors, you use providers, in court, it will be very, very thoroughly analyzed whether you chose your providers wisely, whether they were certified, and whether you instructed them well, in particular with regard to technical and organizational measures, but also with regard to how personal data needs to be processed, and whether you audited them adequately. So you basically can see how complex these cases become. And the exculpation level is pretty high in such a work-sharing model.
And Tim, do you think that we will see more audits in the upcoming years? Because this is something we were facing quite the last years. Some of our big clients did audits on site in our data center. I mean, how could you audit the cloud? This is an interesting question as well. So do you see I don't think it's a risk, but do you see that there will come more audits?
Short and undifferentiated answer for a lawyer, yes, definitely. We already see that.
Yeah.
You see a strong increase in audit requests and in certification requests.
Yeah.
Certification is an even stronger surge.
Yeah.
But yes, audit is something. If you look at it from a litigation perspective, from a defense view, you get certifications in place. You can prove that you did your audit. That's a case you can defend. So let me be clear. In these cases, it's not about right or wrong. It's about winning the case and proving that your client is innocent. And as you can imagine, audit helps a lot. Regular audits and having the instructions you give to your provider in good shape, like in a shape that you are happy to present to a court. Let me be very clear. In everything you do, the benchmark is not to make any data privacy gods happy, but to be in a good and defensible position when it comes to court or when it comes to a regulatory probe. So it's really having your documents at hand. Like doing everything perfectly right doesn't help you if you're not able to prove it. And then, and your question links directly to that. Not only having done the audits, but documenting that properly.
Yeah.
If you look at mass actions, what are we seeing at present? We are seeing a huge number of cases, particularly in the UK and in the Netherlands. And if you look at the volume in the jurisdictions where they have the mechanisms, for the legal mechanisms for class action with an opt-out scenario, where a firm can claim that it acts for everyone affected, and people would actively need to opt out, you are already talking about the millions and billions in some cases, like the huge hotel chain, or other cases where large IT providers are on the defendant bench. And these opt-out mechanisms, that's something that goes very fast. You enter a claim, get it registered, get a litigation funder, because this is going to cost a lot of money also on the plaintiff side. But keep in mind, this is going to cost a lot of money on the defendant side too. Like the legal defense against a mass case like that, that's something where you don't want next door lawyer, but where you want people with a deep knowledge in litigation and data privacy and experience in these cases. And even where you don't have the mass action mechanisms, keep in mind, if, let's say, a small consumer firm wins one single case after a data breach, I'll stick to this example because it's so vivid and we see a lot of those. Let's say a small firm, one plaintiff prevails with one case. Guess what's going to happen on the marketing end? Like, these guys are going to market like hell, saying, we won our case. This is something which is exactly the same set of facts we will have in a million of other cases. So it's not only about the civil procedural laws. It's also about, in any jurisdiction, you lose one case and it's going to be a feast for litigation funders. And one thing we see is that these firms are very active in their press analysis. As I said, the bar is 4 hours after a data breach became publicly known, after the first reports get out. And you see that these plaintiff lawyers, these litigation funders, the legal tech firms doing this, we actually got in Germany one very sophisticated legal tech firm that normally gets on airfare delay claims and something like that, have pretty much shifted their business model in order to include data privacy claims.
I mean, since we're all not flying that much anymore, that's a clever idea.
I can see the economical wisdom behind that. If you want to take a look at it, you may wish to visit the website of Right Now, and you will see how they operate. And lawyers in general don't talk well about their competitors. And in particular, they don't have a reputation for talking well about their opponents. But we see some really clever and sophisticated mechanisms on the plaintiff side. And sure, does it make sense to buy those claims from a commercial angle? If basically the courts decide in favor of plaintiffs, and we're going to know how this is going to go on a national level, we will have a first indication within a year. We will have binding court decisions maybe 2 years from now in the last instance. However, this is going to be all in the open again if only one court decides to bring this to the European Court of Justice. So this is going to be a very interesting field until then. And that's why we see a lot of these cases. And again, I'm only talking about very, very simple cases like data breaches. If you imagine anything where you have a commercial background, that's also an angle you can think about. We already mentioned the importance and practical relevance of Article 15. That's the one with the data subject access requests. And we already described that the Arbeitsgericht Düsseldorf, the labor court in Düsseldorf, awarded 5,000 euro to a plaintiff. Let me be very clear. This is not the case law in Germany. So please don't understand this in any way as alarmist. This is just the first instance. There surely is going to be a second instance ruling on this unless the parties close the case with the settlement. And it's, in my knowledge, the first case where these GDPR claims were treated like that. Mm-hmm. So it's just an example of how things may go. But again, and the case is very interesting. If you want to read about it, you will find something or a lot of it on our blog, on our firm's blog. The case has been very interesting. Someone who used to earn 144,000 euros per year, a former employee of the defendant, as the court puts it, filed for immaterial damages, and he filed for an entire annual remuneration. So he claimed 144,000 euros in immaterial damages for the fact that, as he stated, his data subject access request, I'll abbreviate this as DSAR, as our friends in the UK would do, was not responded to timely, and when it was responded to, the court found that it was intransparent. And this is a highly interesting case because the court itself said that in response to the DSAR, the firm provided that plaintiff with hundreds of pages of documents, and they said that this is not sufficient. So that's something you can argue that way by saying Article 12 demands a transparent information, but in my view, it's a wide shot. And let me be clear again, plaintiff lawyers will show you the totally opposite perspective. It's their job, as my job is what I do right now. So what I do is subjective, what they say is subjective, and again, we're going to see how this plays out. However, it's been a highly interesting case, and one of the reasoning of the judgment is highly interesting. Because the reasoning behind that judgment, and you can see that this judge put a lot of work into this decision, was, among other things, that this high amount for such a minor transgression was necessary in the view of the court because of what in the EU you would call the principle of efficiency. I can translate that into normal English very quickly. Where you apply national member state law, like damage civil procedural law, you must apply it in a way that it provides an efficient protection or an efficient enactment of EU law. So you have this Article 82, and the court just said, well, you've got this principle of efficiency of EU law, and the recitals also mention of Article 82 also mention this principle. So they say, we established that the principle of efficiency requires that you need to award high damages, because otherwise Article 82 would not be dissuasive. We, of course, say Article 82 is not meant to be dissuasive, but rather Article 83, and where the word dissuasive is explicitly mentioned. Article 82 doesn't mention it, so we think that it doesn't need to be dissuasive. However, the court was very clear that this was necessary, and a very interesting fact was that they said, okay, if you want damage claims to have an effect on defendants, on controllers processing personal data, it must be high. Particularly where you have a financially strong defendant, because otherwise it would not have this dissuasive effect. It's interesting, pretty alien to German procedural law and also pretty alien to other EU member state laws. But we're gonna see how this plays out in time.
Okay. Let me give you another question, Tim. We just received one more about the bundling of claims for damages. Do you see the way? Do you see a way of bundling claims outside the German model, Musterfeststellungsklage, for example? If users have their data in telephone directories, they cannot have been harmed in the same way as others who do not publish their data this way. This creates a heterogeneity on the part of the claimants, which would be an obstacle to bundling, right?
Yes, that's right. However, what we already see in cases like that, if you look at modern legal tech tools, and let me be very clear, this old school lawyer attitude, we don't need that. In my view, that has been a thing of the past for a long time. So of course we use legal tech. I mean, Latham is a legal firm, and legal tech gives you a chance to become faster, to become more efficient, to deal with particularly where you deal with a huge number of lawsuits, just to administrate and coordinate that properly. So legal tech is a huge element here. So what do plaintiffs do in these cases? They basically create several populations and try to raise synergies on these populations, and then you normally end up with a couple of groups. I guess in the scenario you mentioned, maybe 2-3 general ways how the data was disclosed. Mm-hmm. And if you look at the way legal tech litigation software works, it makes it so easy. And then obviously there's an analogy here. Like, we see that some of the plaintiffs' lawyers come from an exhaust litigation world, so to speak. And we are using exactly the same software that we are using in diesel claims. So, and it's pretty similar. You actually see the same lawyers in some instances. And then, candidly, if our litigation team wouldn't have this vast experience with these tools, but Knowledge Tools is one of the really good providers, we wouldn't be able to manage this huge number of cases.
Yeah, that's a strong trend. Yeah,
I mean, that's not our main topic, but it's not the question of whether you use legal tech as a lawyer in 2020. It's very funny when you hear this fear of, normally, I'm going to be a little politically incorrect, of people who are as pale as I am and as male as I am and even older, if possible, who are afraid that it takes away their business. No, it's not the question of whether it takes your business away as a lawyer. It's a question of making you more efficient. And in my view, it's not a question of whether you use legal tech, but for what purposes, for what tasks, and to what degree. And obviously as early as possible.
Let me give you another question, which just comes up. Will working with a data processor who is formally and independently certified regarding GDPR requirements give me, as the data controller, more security compared to a provider who would only claim to comply with the GDPR? That's an interesting question, because we are asked a lot that way.
It's a nice one, actually. It's a good one, and thanks for the question. I personally, I love it, because there are so many truths in there. First thing is, there is no thing as a GDPR certification in the EU so far. Yeah. What you can testify, what you can certify, is IT security. So to answer your question, if there were something like a GDPR certification, and we are in very, very lengthy discussions with the data protection authorities about that, because we want GDPR certifications. That's what would make everyone's lives much easier. but it's not there yet. And I personally believe it's going to take a while until we see proper GDPR certifications.
That's what we hear as well, yeah.
But what providers might be able to offer, obviously, would be ISO certifications. We see IT certifications in Germany, for instance, the Europrice, or not only in Germany, but also in Germany, label. So there are a couple of very good IT certification standards out there. And to answer your question very clearly, yes, it's helpful to have that. And to also answer the other part of your question, which I need to reread, a provider who would only claim to, quote, comply with the GDPR, unquote. I get a little hesitant when I hear, oh, I comply with the GDPR. That's, I hope you do, otherwise that would be a bad indicator. So, but to answer the underlying question, yes, certification is key. If you get good IT certification, this can be enormously helpful. And keep in mind that you've got a lot of branch-specific certifications too in some fields of business. But even a general ISO certificate is much better than having nothing in place. And believe me, it's something you can use very well in court.
Yeah.
Legal impact of the GDPR. We already basically discussed that, so I'll flip over the slide. But what we see these days is a huge discussion on, okay, Article 15 GDPR also mentions a right to a copy. What does that mean? We basically had a judgment by the Superior Labor Court Stuttgart that was recently declared void by the Federal Court of Justice for the reason that the parties had settled. But they pretty much said that a copy means a copy of everything. By the way, anyone who has only basic understanding of how modern IT works, you cannot generate a copy of everything because it's all interlinked. You would have to provide the entire content of your IT system, of your IT systems, and I haven't seen a firm who's able to do that. If you were, in theory, able to do that, you would need to redact everyone else from that, which would be, otherwise you would violate the GDPR by disclosing that information. So that's an interesting playing field. Data subject access requests, what we see work in practice and what German authorities normally accept is a staggered approach. So at the first level, you provide a reasonable degree of information where you have the possibility, you use IT, you use online portals to deal with that. Keep in mind that the person needs to be properly identified. So that's the perfect opportunity for identity theft. And you don't want to adapt this because this in itself would be a great way to get to the defendant's bench in court. And it's also a great way to receive friendly attention of the data protection authorities. So identity is key whenever you respond to any DSAR request. Let's go to, basically we had the perfect introduction for that by now, to fines in the GDPR and the fining model that was developed by the German Conference of Data Protection Authorities. One thing to save lifetime for us all, when I'm talking about the German Conference of Data Protection Authorities, I'll abbreviate, the German term for that is Datenschutzvgrundverordnung. I'll abbreviate that as DSK. So when I'm talking about the DSK, that's the joint collaboration body of the German federal and state data protection authorities. Some background, most of you will know that. I'll go through that very, very quickly. The fines are very high. It's up to 2% or 4% of the global annual turnover. There's a strict discussion with the data protection authorities. The data protection authorities say that this means group turnover, the economic entity, which basically boils down to the corporate group. In most cases, we say, no. We have a lot of defense cases there too. We say, no, it's the legal entity itself and not the corporate group. The recitals say differently. Let me be clear about that. However, such a material change of the wording of a sanctions norm can't be effected in recitals. You need to have that in the wording of the law itself. That's our view. The view of the data protection authorities is entirely different. We are defending one client in a case where a 2-digit million fine was imposed, and that's not binding, it's contested, and it's contested in the district court Berlin. And we are pretty positive to, at some point of time, hear more from that direction. It's going to be interesting whether they will see recitals as sufficient to say we charge the entire group. Mm-hmm. If you look at the figures, this group mechanism would create. If you take a large German stock company, and any one of the big ones, you end up with figures that are highly surprising. You end up very, very quickly in the billions of euros, even for a minor violation. So that's what's possible in theory. What have we seen so far? We have seen the British ICO announcing, and let me be clear, announcing means not imposing. So it's not a legally binding decision, but rather they did an investigation, and the two companies they had in target were under the obligation to publish the information that they were being investigated. And so everyone went public in that scenario. And the ICO, the British Data Protection Authority, basically published their intention to fine a huge aircraft carrier with 100 million euros, roundabout, the figures are in pounds, that's not precise, and a huge hotel chain, we already discussed them, with 200 million euros. So we are talking about a lot of money. However, let me be clear, there's not even yet a fine order on this. Let's wait and see how the final fine order looks and what the figures on it are, and then it makes sense to discuss that. If you...
sorry, Tim, since we only have 10 minutes left, may I ask you to combine this with a quite recent development of Schrems? We've seen the fines, we understood the trends, and what does it mean now with the latest news on Schrems II?
With the news on Schrems II, it basically boils down to a scenario where you have seen one fine of 9.5 million in Germany, where you have seen one other high fine of 14.4 million euros. So to answer your question, do German authorities impose fines? Yes. Are they on their own? No. Austria has fined 18 million, France 50 millions. So we are talking about quite high figures. What we see now, if there is a fine, the plaintiffs ramp up immediately. So there is a lot of effect. And moving on to Schrems and the basically data transfer mechanism we're talking about. For anyone who wants to read through the highly complex fining model of the DSK, good fun. The gist behind it is, and you can find more information on this on the links we have provided. The gist is that the model has the result of ending up on the high end of the fining range. So that's what you should keep in mind, because that brings us to your other question. And talking about what usually is being referred to as the Schrems ruling, which has been brought along by data protection activist Max Schrems and his association. It's not only his association, obviously, it's the Privacy Association, None of Your Business, NOIB. What has happened? Very simple. Basically, there was a case in the European Court of Justice, in the ECJ, and Neub contested that the privacy shield was valid. The privacy shield was basically an agreement between the EU and the US, and to transfer personal data from the European economic area to any third country outside of the EU not having an adequate level of data protection, you would need other mechanisms to create this adequate level of data protection. Otherwise, data transfers outside of the EU, EEC, are not legally permissible. There are a number of mechanisms to provide this adequate level of data protection. One of them has been the privacy shield mechanism, and the EU has declared this as void. The interesting question is, what do you do with that now? First thing, obviously, it's not legally permissible to transfer personal data based on privacy shield, pointing out the obvious. However, if you look at the criticism of the European Court of Justice, they pretty much criticized that you had no legal standing as a non-US person in the US against intelligence services accessing personal data, requesting personal data, issuing orders to receive personal data. And they very generally criticized the competences of US services to acquire personal data. So that's quite some authorities in the EU, all data protection authorities actually, argue that this criticism also refers to other data transfer mechanisms, notably in particular the standard contractual clauses. These are contract clauses established by the European Commission. You use those clauses, the recipient and the data exporter comply with these clauses, and that in itself generates the adequate level of protection. And what the data protection authorities say these days is that the criticism of the European Court of Justice also applies to these mechanisms, to the standard contractual clauses, the SCCs. And what they pretty much say is, what the authorities pretty much say is that you need an extra risk analysis for this specific data transfer. So wherever you use a provider, you need to basically be in a position to have a max Schrems, or Schrems II as the judgment is called, risk analysis in place. Do I personally believe that this makes a lot of sense? I don't know. In my personal view, the European Court of Justice has issued a very political judgment. And this is a political conflict. The fact that one administration is not willing to come to terms with another. I strongly doubt that it is fair and proportionate to basically push this to every single enterprise transferring personal data. But at the end of the day, it's what it is. It's a binding European Court of Justice decision. And so basically we have a lot of work helping firms with establishing a defensible position. And let me be clear, it's not about making everyone happy. It's about when the regulator asks, when you have a claim to defend against, to get into a defensible position. So personally, I am talking about litigation. I'm also talking about privacy law, not just privacy. But at the end of the day, it's a litigation question. So in a nutshell, the European regulators demand that you do a risk assessment. And if at the end of this risk assessment, you come to the result that you're not permitted to transfer that data any longer, you can address the data protection authority and ask them, oh, I feel that the level of protection provided is not sufficient. What's your view, dear Data Protection Authority? I think the likely answer I can predict that pretty surely. And if you then go to court against that, I'm pretty sure the judges will ask you, okay, you just told the authority you yourself believe that the level of data protection was insufficient, and now you're going to contest that decision. I don't think that's a hard one. That's not a downhill.
Yeah.
So
if I might bring another question and really put it to practice, what about the security of my data at US data processors? Well, obviously, third parties like the provider itself and even security authorities can access the data. I understand that this was also one of the main reasons for the decline of the privacy shield by the European Court. So am I currently at a risk if I continue to work with a US provider after Schrems II?
That's an interesting question because it's a little complex to answer. Let me try to answer this question from a very, very practical angle. Do I believe that European data protection authorities are in a position to enforce a prohibition of any use of international IT providers? The answer is no. Do I have a certain risk? Certainly. And what you do here is there is not going to be any bulletproof 100% solution. Let me be clear about that. The ruling is as it is, and it's highly unpleasant from a commercial angle. I very strongly hesitate. I will still have to meet the first client to whom I say, why don't you just stop your cross-border data transfers at all? I don't see myself saying that in the near, middle, and long future. However, what you need to do is, as long as we all agree you're not going to find the perfect solution, and if someone knows the perfect solution to deal with that judgment, I'll be happy to take it. So far, I haven't heard it, I haven't found it. So with this really suboptimal situation, what you do is you assess your data protection, your data transfers, and classify them, not only with regard to relevance, but also with regard to sensitivity.
Yeah.
And if you look at you got to analyze the court ruling to come into an adequate defense position. So one of the main criticisms was the so-called FISA, an act on foreign surveillance intelligence, that basically permits US authorities to access personal data. However, if you look at it, and obviously that's not my knowledge, that's something I've taken from my US Latham colleagues. This is an act that aims mainly at telecommunication providers. So that's one thing you put into your risk assessment. You look at the type of data being transferred. Is this something that's highly relevant to US intelligence services? So, for instance, when you're in a position that you gotta justify, gotta defend your intra-group personal data transfer on customers, on let's take employees. It's not really likely that US authorities are going to be interested in employee data. They are looking after terrorists. Can I exclude it entirely? No, I can't, but it limits the chances. So, and what you got to do is you got to look at the expectations and at the publications, the requirements of the data protection authorities. They demand you to do a risk assessment. Is that the 100% solution? No. However, it's at least defensible. When you don't do such a risk assessment and when you don't have the necessary documents in place, same topic as we touched base on a couple of minutes ago, then it's very easy for the authorities to go against you, and the risk of fines, of damage claims, of whatever regulatory intervention increases massively. So I'm not saying you need to I'm not saying someone already has found the perfect risk assessment. However, there are a couple of similarities that come up again and again, and we go through these mechanisms with a huge number of our clients and say, okay, this is what we see as state of the art, and you may wish to take a look at this sample or that sample, and that may help you getting there.
But as you've said, I mean, it's about classifying the data, and you know, our roots at the question of incident reporting, whistleblowing. Of course, this is sensitive data. So from our perspective, we would always say, I wouldn't put that at any risk.
I think you can very safely say that you get sensitive data here in a whistleblowing context, and you can also say that this is data that needs to be protected. So I'm not going to generalize on how this needs to be done, but this is something where you can be pretty sure that the data protection authorities are going to have their opinions. And whenever an enterprise is unsure about how to deal with these things, I know that there is something like a reflex not to go to the data protection authorities. First of all, this reflex is unfounded. I haven't seen one single case where an enterprise, a company went to the data protection authority and they ended up with a fine. I haven't seen one case, and I've been doing this for more than 20 years by now. Next thing is, even if you still are afraid that it might happen because the request you're asking is so sensitive, go to your lawyer. They can go to the authority on a no-name basis and just ask your question. So,
and I know Tim for a long time, and I know he has really excellent connections to a lot of the authorities. So therefore, maybe I could hand over to I think our last question for today. Tim, can you recommend a blueprint or a guideline for the risk assessment?
Yes, I mean it's going to be your risk assessment. Like the structure, the model, we have a lot of templates on that, but it's going to reflect the data protection requirements applying to this specific category of transfers. So one intra-group HR data transfer is something you can take a look at, and it's not too far away. When you basically take a look at a good sample and at good templates, you have some ideas that you may wish to consider that make your lives easier. And again, it's a bad situation. I don't think there is the 100% legally safe solution, but it's just about having first a risk assessment in place, because not having a risk assessment in place, that's what puts you at risk. And so my experience from discussing these things with data protection authorities, they are happy to see a risk assessment at all. I mean, not just a sham, but something adequate way to see there has been work done. But if they see that, the reaction we have seen so far, that's highly interesting. And one thing which I found highly interesting, and then that's also interesting in another context, we see that the German BaFin, the Financial Supervision Authority, it's the first time I've seen that this morning, so it's something of news. They are among their supervision competencies, it's also to look at outsourcings. And that's something they look at very thoroughly. And this morning I have seen, it's the first time I've seen something like that. And candidly, I don't know whether it's a general operation, whether they do this at large. It's the first time I've seen it so far. And they are sending out letters to insurance companies and other financial institutions, banks, saying, okay, you did this or that outsourcing, and we have seen the Schrems ruling, specifically mentioning the Schrems ruling. We want you to go to the Data Protection Authority and have them confirm that what you are doing is lawful.
Whoa, that's a tough one.
It's a tough one.
Yeah.
And fortunately, it's a client we have done this exercise with. And the period of time to respond is not too long. So we really, this is something which candidly, I read it this morning before I came over here, and I'll have to do with that a lot later today. But if that is not only a single incident, but a general cause of supervisory authorities or the BaFin, the German financial regulator, then we're going to be in interesting times.
Absolutely, absolutely.
And it's going to be interesting to see whether the data protection authorities will be swamped with respective letters, will be able to deal with a huge number of requests.
That's going to be really an interesting one. So sorry, we are running out of time. I think we could discuss these topics for hours, and it's been around 100 participants. So thank you all very much for showing up and for a lot of questions. Unfortunately, we haven't been able to answer all the questions, but let me give you a hint. Tim publishes a lot, as you all might be aware, and there's some of his publications are available via the Latham site.
LathamGermany.com.
Yeah, and you could save some money because otherwise you have to buy them. So this as a maybe final hint for everyone. So Tim, thank you very much. It was a pleasure, like always. And I think we should find our next date because, as I see, there are so many questions and so many hints you could give. Thanks a lot.
Thanks for having me.